Hello, I'm Tim Sellers, the director of the Center for International and Comparative Law, and I'm delighted to be here to welcome you to the 13th annual lecture on international and comparative law. This lecture is the absolute high point of the University of Baltimore academic year. Everything else that happens is downhill after this. And I see, as I look out in the audience, our very best students and our very best faculty. So I'm glad that we have this, this extremely high-quality group here. The way this is going to work is we'll have some remarks from our speaker, and he has graciously agreed to take questions from the audience. So after his remarks, he'll entertain your questions for some period of time, and then afterwards, we'll go out and there will be a reception, I'm told, waiting for us on the other side of the door. So once the talk is over, you'll have an opportunity to speak more informally with the speaker and with each other and with some of the faculty colleagues who are here. Our speaker today is Jan Klabbers. Jan Klabbers was educated and has all his degrees from Amsterdam, but he went on to a career in Finland at the University of Helsinki, where he has been since 1996, most recently as Professor of International Organizations Law. He also directs the Academy of Finland Center of Excellence in Global Government Research. And in fact, he is very excellent. He's one of the world's leading authorities on international obligations and on international institutions. And his remarks today are going to cover both of those areas, because he's going to be telling us about the reception of international law by the European Court of Justice. On a personal note, Jan Klabbers has been an excellent and much admired partner in the European American Consortium for Legal Education, and I'm very grateful for the wonderful work he's done in that connection, as well as for the lecture that he's about to give you this evening. Professor Klabbers.
The high point of the year, eh? Okay, don't add pressure, please. Ladies and gentlemen, let me first express my gratitude to you all for being here on what could be a very historic evening for this country. Thanks to Professor Sellers for having me. I'll be speaking about international law before the European Court of Justice, or in the European Court of Justice, however one wants to refer to it. Now, why that topic, which is rather esoteric, one would think? The first reason is because when he approached me, Professor Sellers said I should do something with parochialism and international law. So I thought a bit, and then I thought, oh well, the European Court of Justice fits that bill rather nicely, rumors to the contrary notwithstanding. The second reason is that I actually have a book out on the topic, coming out on the topic. So, you know, book promotion, flash, pluck, pluck. Amazon.com, you know what to do. Thirdly, and perhaps the most important reason, though, is that precisely 2 months ago, the European Court of Justice came with a highly relevant decision, finally clinching its parochialism in a case involving the connection between EU law and United Nations law. The CADI case. You may have heard of it. If you haven't, you will later on, because that's going to be more or less the focal point, or the culmination point, I guess, of the talk. And talk it is. That particular case is the talk of the town in all of Europe. And not a day goes by, and I'm not exaggerating now, that I don't get an invitation to speak on that particular case. And I'm presumably not the only one. So that's what Medellin versus Texas would be for American constitutional lawyers at the moment, that sort of case, the CADI case. Okay, one of the more vexed and central issues in public international law is how the international legal system, the international legal order, can cooperate with domestic legal orders. How does international law enter into domestic law? You can imagine that in the absence of an international police force, in the absence of an international prosecutor, in the absence, or almost absence, of international courts, that a lot of premium is put on the role of domestic legal systems in helping to enforce international law. So, for the effectiveness of international law, it is quite relevant that somehow it enters into domestic law. Now, traditionally, the common ground, the received wisdom was that the extent to which international law and the method by which international law could enter a domestic legal order depended on that domestic legal order, depended on the constitution of that particular country. If the constitution would allow for treaties to be self-executing, then so be it. If the constitution would not allow for treaties to be self-executing, then so be it as well. In that case, and the United Kingdom is the textbook example really, in that case treaties would have to be transposed into the sort of legal act that that particular local system would recognize. In the UK, the main idea is that acts of parliament are supreme, so any treaty, any international obligation that the United Kingdom government enters into will have to be transposed, transformed into an act of parliament. That's common ground that used to be received wisdom. And it's a bit of a quaint area of the law, really. It is lawyers' law, or really lawyers' law. Now, some of those received wisdoms at the moment are becoming unhinged, are becoming unreceived. Classical notions concerning monism and dualism, which is how those two things are usually referred to, are being turned on their head. And one could even go so far as to claim that sometimes domestic courts nowadays make a mess of things. One illustration, one manifestation of the fluidity at the moment, of the way that received wisdom is becoming unreceived, is the case I just mentioned from the US Supreme Court, Medellin versus Texas, where the Supreme Court displays a slightly worrying lack of understanding of international law, and perhaps more to the point, refuses to give any effect to it. That same trend, if a trend it is, and I'm afraid it might be, that same trend has been visible in the literature for some time already. Conservative scholars have pointed out that international law is dangerous because it is foreign, and thus the domestic legal order ought to be protected against international law. Liberal scholars, slightly more intelligently perhaps, have claimed that international law is not so much dangerous because it's foreign, but it's dangerous because it's undemocratic, which actually is a stronger argument, I think, than it's merely foreign. And therefore, the domestic legal order ought to be protected. One sees those trends in US scholarship, one sees those trends also in Europe. Now, the US has been accused of a certain amount of parochialism for quite some time. Think back to the 19th century Monroe Doctrine, or at least the isolationism that gave rise to it. Think back to the Senate refusing to back Woodrow Wilson's plan for a League of Nations back in 1919, 1920. Think also of the more recent expressions of exceptionalism warmly embraced by the still current president in his reluctance to sign up to the International Criminal Court, his reluctance to sign up to the Kyoto Protocol, to name just two of the more visible manifestations. By contrast, the European Union is always portrayed as far more international law friendly, völkerrechtsfreundlich, as the Germans put it in a concise, if rather lengthy term. International law friendly, that would be the attitude so many people claim of the European Union towards international law. And many people explain that then by saying, well, the European Union is itself, based on treaties, is itself a creature of international law. So it stands to reason, right, that it would be more sympathetic to international law, that it would be more eager to welcome international law, to allow international law to have certain effects in the EU legal order. Moreover, another additional argument here is that EU law itself claims to be self-executing in the domestic legal order of its member states. So you could draw a straight line, member states, EU law directly applicable, EU law directly self-executing. Hence, it stands to reason that international law ought to be, through the same sort of logic, self-executing in the EU, right? So far, so good? Wrong. because the EU does things rather differently. It wants to have its cake and eat it too, as the saying goes. It is true that EU law itself claims to be self-executing in the domestic legal orders of France and Germany and Italy, all its 27 member states. What is not true is that the EU itself would be so international law friendly. At least not if the European Court of Justice is to be believed, and I guess one should believe it on this particular topic. At this moment, it's perhaps prudent if I take 2 minutes to explain the basics of the European Union, because I don't have a clue what you guys know about the EU. So maybe 2 minutes. Bear with me. If this is all common wisdom, then feel free to doze off for 2 minutes. EU was created early 1950s between 6 states, France, Belgium, Holland, Luxembourg, Germany and Italy, so as to help recreate Europe as an economic force, while at the same time trying to prevent it from falling for the temptations of communism, which was pretty much on the rise in the 40s, early 50s in Eastern Europe, right? The trick to do that was to create what has been called a supranational type of organization, whereby certain policy areas of those 6 states, in particular at first the coal and steel area, were to be brought under a common type of regime, to be subjected to common decision-making, and that decision-making would be self-executing in the member states concerned. There were only 6 of them at the time, and in 1951, when the European coal and steel community started, it only concerned the coal and steel sector, on the theory that if you control coal and steel, you control the heavy industry, you control the stuff that military armaments are made from, and therefore you can prevent the Germans, because those were of course the bad guys in those days, prevent them from becoming a military powerhouse again. You can help them become economically strong by pooling resources, while simultaneously preventing them from becoming militarily strong. That makes sense? That was the long and the short of it. Now, how does one create such a thing? It's been done on the basis of a treaty and by means of creating various institutions, various organs of governance, if you will. Decision-making typically takes place in a complicated interplay between an executive body, the Commission, plus a council of ministers, delegates as they are from the member states, nowadays also involving a European Parliament. But the most important entity for our purposes is the Court of Justice, which comprises 1 judge from each and every member state, meaning 27 judges at the moment, plus 8 advocates general, which I don't know what the equivalent in the US would be. There might not be an equivalent. The Advocate General is supposed to sort of, without taking any sides, lay down the law and hope that the court will follow it. Sort of an investigative position. Now, that system worked really well, reasonably well at least, since the 1950s. Late 1950s saw the addition of an atomic energy community, plus, more importantly, a general European economic community, by and large coming to cover pretty much all of economic life in Europe. That worked reasonably well, as I said, and the number of cases before the European Court of Justice increased dramatically, also because the number of member states increased quite dramatically over the years, as a result of which the court suffered from a rather heavy workload by the 1980s, and a second court was created, a court of first instance. I wouldn't have mentioned that otherwise, but it's of importance for the case that we will be discussing later on. So there we are. A court of first instance created in 1989 to help alleviate the burden a bit. Right. Now, that European Court of Justice, which technically includes the court of first instance, together they form the judicial apparatus. The European Court of Justice has been fairly reluctant to embrace international law. As I said earlier, EU law itself is supposed to be self-executing in the domestic legal orders of France, the Netherlands, Belgium, you name it, regardless of what the constitutions of those countries have to say about it. But EU law itself proclaims to have a certain separate status still. Typically, international treaties are not considered to be self-executing in EU law. That has become clear since the early 70s when the first cases arose asking, or where private parties would ask the court to test legislation, EU legislation, against the EU's international obligations. And the typical response of the court would be to say no can do, because those obligations, in particular those arising under the international trading regime, the GATT, as it was called, the General Agreement on Tariffs and Trade, nowadays the WTO, those were not supposed to be self-executing. There are other strings of cases which also mark a reluctance of the court to do anything worthwhile with international law. There is, for instance, one treaty provision in the founding treaty, Article 307, which protects, on its face, protects the agreements concluded by member states of the EU before they joined the EU. So you could imagine if France concluded an agreement with the US in, say, 1947, that under the letter of Article 307 of the EU treaty, that agreement would be protected, right? So the EU was not even in existence back then, and the EU cannot be in a position to tell France to renege on its commitments towards the US. Does that constellation make sense? Okay, think again then, because that is precisely what the court has been doing. It has said, yes, there is Article 307, yes, hypothetically those treaties ought to be protected, but the member state concerned should take any steps to eliminate any incompatibilities, even to the point where eliminating any incompatibilities might mean terminating a treaty unilaterally, which is not something one should do, normally speaking. Nice example are a bunch of maritime agreements concluded by Portugal in the 1970s, before Portugal joined the EU, which could not pass the test laid down by the European Court of Justice. And on the fateful day, 4th of July 2000, the Court of Justice decided that Portugal was under an obligation under EU law to terminate its agreements, which included agreements with Angola and the former Yugoslavia. You can imagine Portugal's response being, well, wait a second, even if we would have wanted to renegotiate, who do you talk to in Angola? The civil war going on, that sort of thing. Who do you talk to in the former Yugoslavia, at least in the 1990s? But court said, no can do, no excuse. You should simply have terminated any incompatibilities a long time ago. So that's one string of cases. Another string of cases deals with human rights law. As you may know, apart from the EU, there is also a European Convention on Human Rights embodying fundamental rights, fundamental liberties. You can also imagine that sometimes a conflict between EU law and human rights concerns takes place. And a good example is a case, again, from the year 2000, a case of an Austrian trucking company which was transporting produce from Austria through Italy, had to go through a mountain pass. The mountain pass was blocked with permission from the Austrian authorities in order to facilitate an environmental protest day. The trucking company proclaimed that this violated the free movement of goods in Europe. Of course, the Austrian government said, well, we gave the license to the environmental activists because we thought human rights, etc., freedom of speech, freedom of assembly, that sort of thing is useful. The court ended up looking at the case, construing freedom of speech as a possible exception to the free movement of goods. Think about that for a second. So the free movement of goods, EU law reigns supreme, might on occasion perhaps be set aside by human rights concerns, by fundamental freedoms concerns, by freedom of expression, but only on occasion. So EU law prevails in a case of conflict with human rights concerns, which may or may not be acceptable as a political matter. And then there's this recent case, which deals in a complicated way with sanctions imposed by the Security Council. You're aware, I presume, that the United Nations can and does impose sanctions both on member states, but increasingly also on individuals, right? The United Nations can do so. Under EU law, the idea is that those sanctions decisions coming from the various sanctions committees of the UN are to be transposed into an EU regulation, which is one of the pieces of legislation that the EU can use. In this case, it concerned a gentleman named Kadi, who was a businessman from Saudi Arabia residing in Sweden. And he went on a Sunday morning, or maybe a Tuesday morning, don't catch me on the details, something like that. He went to his ATM, tried to withdraw something, and couldn't. ATM was blocked. So he said, well, what's going on? My funds should be more than sufficient to get a few euros out of the machine. So what gives? Well, what gave was that the gentleman in question, Mr. Kadi, had found himself unwittingly on a blacklist drawn up by the Security Council Sanctions Committee dealing with sanctions, overseeing the implementation of sanctions against Afghanistan. You still with me? If not, let me know, please. So Mr. Kadi found himself on a blacklist involving sanctions against Afghanistan. He had not been made aware of that. He had not been informed of that something was amiss with him. He tried to go to court in Sweden where he was residing, but that didn't work because Sweden said, sorry, it's not our responsibility really. You have a problem with the EU regulation and in turn with the underlying Security Council action. Now, the Security Council doesn't have a court or anything. You can't go on appeal. You can't get those decisions reviewed. So the next best thing was to go to the EC courts. He ended up before the court of first instance at first, because that's where this sort of cases then ends up, complaining that at least two of his fundamental human rights had been violated, one being his right to property, which makes some sense, I guess. The other being, perhaps even more sensible, his right to have access to justice, precisely because the UN did not entail any procedure for reviewing the legality of sanctions decisions. He claimed that he had been found guilty without a fair trial and had no way of trying to prove his innocence. The Court of First Instance came up with a decision in 2005 which was rather controversial. It found that Mr. Kadi could have approached the Swedish government could have approached the Security Council. So there was something of a procedure to get delisted. It may not have been really a judicial procedure, may not have been an independent tribunal to go over those things, but at least something of a procedure existed, so the Court of First Instance said. And that should be enough. You know, in the fight against terrorism, who looks too closely at the right of access to justice? Moreover, the Court of First Instance decided the right to enjoy property had not really been violated, because after all, freezing of the guy's bank account was only a temporary matter. It could take some time, of course, and it's a bit awkward if you have to pay the mortgage, but nonetheless, it was only temporary, so no real violation of the right to property. Now, obviously, Mr. Kadi didn't take this lying down. He was wealthy enough, by the way. He had a few other bank accounts as well outside the EU, which helped matters greatly, no doubt. So he went on appeal, and on appeal, the EC court, so the higher court, came up with a decision 2 months ago, which will prove to be even more controversial than the original decision. The original decision simply wasn't very good, I think. The Court of First Instance made a bit of a mess of human rights. At least none of my human rights lawyer friends would recognize himself in the reasoning of the Court of First Instance. And that makes sense, because the Court of First Instance, of course, is basically people who do other things. They tend to be drawn from tax offices, those judges. They tend to be drawn from antitrust offices, those judges. So if they get a human rights case, obviously you can imagine that some confusion will enter the picture. But that's neither here nor there. The more recent decision will prove even more controversial because the court ends up saying that it could not care less about the United Nations. And that's a bit awkward in light of United Nations law itself, because if you would go through the Charter of the UN, its foundational document, its constitution, if you will, you'll see that in Article 103 of the UN Charter, there's a clear injunction that UN law prevails over other international agreements that the members of the UN may be party to, and that would seem to cover also EU law. This now, to the European Court, is of no concern. What the European Court does in this particular case, in this CADI case, is to say that as the EU Court, its task is to apply EU law, and it couldn't care less about United Nations law. EU law would entail, so the court rather liberally, I think, sketched, would entail also respect for human rights. Ergo, Mr. Kadi can rightfully appeal against decisions coming from the EU which would affect his human rights, or potentially affect his human rights. And the fact that those EU regulations are supposed to implement earlier Security Council resolutions is neither here nor there. The court simply builds a fence, a wall, if you will, around the EU and damn the torpedoes. Because, of course, the whole point of the UN, the whole point of Article 103 of the UN, is precisely to facilitate sanctions imposed by the UN in their efforts to maintain or restore international peace and security. Right? Okay. So, the Kadi case, to my mind at least, and I'm not the only one, tends to, how shall I put this, firmly lock the European Court's parochialism in place. Now that leaves a few questions, I guess. One of them is, what causes this sort of parochialism? The second question is, can it achieve what it sets out to do, which is to protect the local against infiltration by the global, if you want to use terms like that? And third, is it even necessary to be so parochial? Now, the causes of the European Court's parochialism would seem to be at least three, and I'm not trying to be exhaustive here, but I think I can identify at least three. One is to protect the build-up of European Union law, what in French is called the acquis communautaire, what community law has achieved over the years, and to make sure that that retains its own integrity without being tainted by outside interference. That's one thing. Another thing is reciprocity. The Americans, for instance, the American government, when ratifying the WTO agreement, the World Trade Organization agreement, proclaimed that WTO law would not be self-executing in a US legal order. So private parties cannot claim that any governmental action ends up violating WTO law before a US court. Well, the EC argued, then we'll do the same. We also deny that WTO law can be self-executing in our legal order. The Japanese have done the same as well. So you get the three major trading blocs of the world all looking at each other. And if one of them would open up, then the rest might follow. But if no one does, then reciprocity would demand that no one else does either. Something like that. And then a third general reason for the EC Court's parochialism would be general globalization anxiety, I guess. The infiltration by the global calls for a local response, local human rights in Europe, even at the expense of the UN perhaps. Local democracy needs to be protected against infiltration by outside forces. Now, I have some sympathy for this latter point, actually, for this stress on community. But there is a break-even point there. When focusing on local issues means giving up on global issues, means giving up on global justice, then I think we have a problem. It's one thing to protect the rights of a millionaire to his property under EU law. But if that means accepting that the UN cannot be left aside, then things might be amiss in a world where violence is still at the order of the day, where interstate and intrastate conflicts are at the order of the day, where tens of thousands of children die of malnutrition every day. We cannot just say, oh well, damn the torpedoes, to hell with the UN, as long as human rights in Europe are being guaranteed. Somehow, I find that difficult to swallow. Or, to continue the earlier analogy, it's also a bit difficult to swallow that Texas should have a right to insist on procedural default, even in today's world. But that's another story altogether. Now, can parochialism achieve its aims? Not likely. The toothpaste has been left out of the tube, and from personal experience you might know that it's pretty difficult to squeeze it back in. Globalization cannot be stopped by building fences. It may be redirected perhaps, it may be influenced perhaps the direction it goes, but we can't go back to the 19th century, can we? And probably the 19th century was less anxious about foreign interference than today's world. Plus, both the US and the EU might do well to realize that sometimes a global solution may also be of local interest, that there's not necessarily always and every time a tension between the two. Think of ecological crises. Surely they don't stop at the Rio Grande. So you might as well do something together there. Think also more topically perhaps of the current banking crisis, which now took everyone by surprise and only illustrates that there is no global regime in place to regulate financial transactions or to steer them or to influence them or whatever term you want to use. Yet it has become clear that the finance sector has the potential to disrupt the entire global economy and could only be prevented at the moment from doing so at huge expenses for the taxpayer. In short, the world has become too interdependent to hide from it. No man is an island, and no country can live in isolation either. So, third question then, is parochialism of this particular kind, as I just sketched it, with Texas versus Medellin, Medellin versus Texas, the Cadi case, is that even necessary? I think not. Public international law, my discipline, is, if nothing else, a wonderfully flexible discipline, containing lots of techniques, lots of possibilities to record disagreement between states. The usual fiction is that treaties, that international law embodies the common will, the meeting of the minds of parties. But nothing could be further from the truth. As a colleague once wrote, treaties are really disagreement reduced to writing. That's not necessarily a bad thing, quite the opposite perhaps. Treaties, international law, make it possible to accommodate a plurality of values, a plurality of nations, of countries, without them getting at each other's throats constantly. So what then does this flexibility entail, rather than having to say international law doesn't bind us, even though we sign up to it? You could prevent international law from affecting you by never signing up to it. That may be politically difficult, CNN may not like it, but it may be a distinct possibility. If necessary, states can make reservations to treaties to record their exceptionalism, their unique position, their substantive disagreement with parts of the treaty, perhaps. If necessary, states can even issue so-called non-self-executing declarations, not by way of what the Supreme Court did, not by way of what the EC Court did, but simply when ratifying a treaty saying we shall not allow it to be self-executing in our domestic legal order. The US pioneered this when ratifying the International Covenant on Civil and Political Rights on the theory, which may or may not be accurate, that US human rights protection was already so good that allowing domestic courts to apply the International Covenant on Civil and Political Rights would actually diminish the level of protection for individual Americans. That may or may not be plausible, but as a technique for limiting the effect of international law, for steering it in your direction, it might be pretty useful. And as we've just seen, the EU, the US, and Japan did exactly the same when ratifying the World Trade Organization agreement. Ladies and gentlemen, as my words suggest, I am a firm believer in the relevance of international law. And I think that today any lawyer should have some knowledge of international law. Anything less borders on malpractice. And I actually mean that, sort of poignant as it may sound. Does not mean that one should accept uncritically anything that comes our way under the heading of international. That would be taking things way too far. Because sometimes international solutions can be toothless. Sometimes they can be silly. Sometimes they can even be dangerous. Personally, for instance, I'm no fan of the International Criminal Court, which I think embodies a solution to a problem that never really existed and ends up taking the element of politics out of political crime, which is probably the worst thing one can think of. Still, having said that, you can't run away from international law as a practical matter, and as a normative matter, it helps us take responsibility for taking care of our common world, to invoke the wise words of the German philosopher Hannah Arendt. Now, with that in mind, let me conclude by once again reiterating what a great pleasure it is to be here in Baltimore, because the University of Baltimore takes its international law very seriously, as witnessed in the work of Professor Sellers, as witnessed by the work of the Center for International and Comparative Law altogether. May it continue to do so for many, many more years. Thank you.
Thank you, Professor Klabbers, for those very learned and interesting remarks. Professor Klabbers has generously agreed to take questions from the audience. And so I call on the audience for their questions, if they have any.
Professor, obviously I haven't read the cases, but from what you were describing in the Austrian trucker case, you said that the European court said, well, in this case, we make an exception. Did I understand that right?
Yep.
And in the Connie case, that they didn't say, in this case, we make an exception. They said, we're not going to apply UN law. We're not going to apply UN sanctions. Am I understanding that correctly?
Yeah. What they did in the Cardi case was simply to bracket the UN bit, so to speak. The UN law has to be implemented, transposed into an EU regulation. The court said the only thing we're interested in is the legality of that EU regulation against the background of general EU law, against the background of the EU constitution. So in other words, what we're interested in, what we'll be looking at, is the constitutional validity of that particular sanctions regulation. The fact that it comes from the UN is of no relevance to us, which I tend to think would be a bit risky in light of the function of the UN. And you could imagine that if, say, Iran were to do that, if Iran were to say, UN law, UN sanctions have to enter the Iranian legal order through Iranian law, and all we will do is test the legality in Iranian court, will test the legality against Iranian law, never mind the UN order. If Iran were to do something like that, or North Korea or Russia, we'd be pretty upset, right? So that sketches the problem, I guess, in a nutshell. Does that answer your question?
I guess in both cases it strikes me, again, I haven't read it at all, but it strikes me that the court was trying to come up with what it thought would be the right result, the just result. And in one case it seems that they said, well, we can carve it out here. But in the Connie case it seems that it was far more sweeping.
My complaint would be that it's sweeping, yeah. I have no problem with the substance of the decision. with the fact that the guy got his right to property recognized, his right to access to justice recognized. That's fine with me. But I do have a problem with the way United Nations law is treated.
Well, I have a question which I hope will provoke these of my students, some of whom I recognize in the audience.
Only some.
My question is maybe well, I was going to ask what's your attitude, and I guess I'll ask that because you weren't too explicit, although I think it came out a little bit in response to this question. But might it not be that in the Kadi case, the European Court of Justice is doing something that American courts also often do in response to international law, which is to say, for example, in response to treaties, human rights are so fundamental that any treaty, let us say, the United States enters into that tries to alter basic human rights, it's not acceptable.
Mm-hmm.
Because law in general is legitimate only to the extent, quoting our Declaration of Independence, that it advances human rights. And so if you have an international legal order, let us say the United Nations, which is detrimental to fundamental human rights, we just can't be understanding it properly. If it seems to require us, perhaps, to deny Kadi his fundamental rights, then it simply can't be what it's saying. There must be something wrong here. If it were what it was saying, then we should have a revolution, because, in other words, basically just defying any legal order that doesn't respect fundamental human rights. So you see this quite often in U.S. cases, talking about fundamental rights. I wonder if that's all that's going on here, just carving human rights out of the UN order and saying it cannot be accepted.
That's no doubt to some extent the case, yeah, that it cannot be accepted that the UN would trample on human rights. And as I said, substantively, I have no problem with that. But there is the other side of the coin, and that side was recognized, for instance, by that other supranational court in Europe, the European Court of Human Rights, which has a separate brief for dealing with human rights issues, that was confronted about a year ago with a complaint about United Nations and NATO troops operating in Kosovo. The European Court of Human Rights said we can't go there because that's the UN, that's NATO, that's acting for peace and security. That's not irrelevant either. So one way out of the quagmire, perhaps not a very satisfactory way, would be to balance things. But even then, I'm a bit troubled by the ease with which the European Court said, forget about the UN, they couldn't care less, really. And you could interpret that as a warning shot towards the UN. You better get your human rights situation in order, or else you'll taste the consequences. And maybe that's appropriate, but still, the ease with which the court did that. And the fact that it fits so nicely in a 50-year-old pattern of cases by which the EC has literally closed itself off from anything international makes me worried. And makes me suspect that it's not so much the sanctity of human rights that the EC is trying to protect, but the sanctity of the EU legal order. And those are not necessarily identical. Could you speak up a bit?
I was intrigued by what you mentioned, that there is no possibility to have criminal law in politics. It's like any kind of politics is decriminalized, and I wonder, so what happens, I mean, why is it so everybody goes out and for fucking just historical event, then it's possible to find out if somebody made a political crime only after 50 or 70 years, or what happened? I mean, this is what I didn't really get when you said that there is no possibility also of international law to have a political crime.
No. I may not have expressed myself very clearly. a number of years ago, the International Criminal Court was created initially upon the urging of a few states to deal with international drugs trafficking. Now you'd say, okay, that makes sense, right? That's international drugs trafficking is an international crime. You can leave it to domestic courts, but you can also set up an international court to deal with that and similar, what you might call common crimes, which have a transboundary element, right? Now that is something that we lost complete sight of. The International Criminal Court, as it stands, deals with war crimes, crimes against humanity, genocide, possibly at some point in time with aggression. It doesn't even deal with terrorism, unless you can squeeze terrorism under crimes against humanity or genocide or war crimes. Now, those are typically things that occur in a very strongly political context, right? Genocide is not a common crime. Crimes against humanity are not common crimes. They're typically crimes committed in a very political setting. By contrast to say, drugs trafficking or human trafficking or what have you. The point of the International Criminal Court now, the way it approaches those political crimes, is by taking the politics out of politics. By treating genocide as if it were a common crime. By treating war crimes as if they would be common crimes. And that I don't think is very smart. And I think that will backfire. But that's, of course, a position. And other people are far more glowing about it than I am. And either think that it will deter future war criminals and genocide committers, or will deter the same people from doing it again once they have sat in UN prisons in Scheveningen for a while. Those are all untested propositions, I guess.
I was curious about that why also, about the politics and the war crime, but you had mentioned, I was thinking about this before with the current financial crisis, maybe some current implications. I was wondering if you might be able to expand upon that. So-called corporate greed, for example, how that might be seen with, certainly it's gotten a lot of attention here. I don't know what attention in Europe, where there might have been overzealous companies or bankers, or maybe the regulation wasn't enough. Just curious what insights you might have.
Well, the reason why I mentioned it is that there basically is no global financial regulation. There's no financial, no system in place to govern the activities of the banking sector, of the insurance sector, that sort of thing. So what you have is 200 domestic systems, if you will. And it is very possible, more than likely actually, that a bunch of those systems have norms that collide with each other. That the approach that the US takes is at loggerheads with the approach that the UK takes, which again is at loggerheads with what Italy does. And that means that it's always possible for people to exploit the loopholes that thus arrive. The corporate greed can thus step into those loopholes, and money can go and flow everywhere where it is most productive perhaps for those who have it, but perhaps at the cost of great instability to the global financial system as it is. That was sort of my point, that it might be beneficial for states to start cooperating on that, to conclude treaties, to govern that sort of thing. That's as far as I want to go on that, really.
And I think we have time for one more question to be selected. Select the person to whom you wish to respond. Professor Klabbers.
This way, yeah, well.
Two more questions.
Sir.
I wanted to ask a question about globalization and what you may see coming in the maybe not near future, but if you were to speak before a UN convention who was assembled to consider ratification of an international constitution or body of law intended to be self-executing among the member states of the UN in their domestic law and thus enforceable, what would be your primary arguments? What would be the kind of exigencies that the world needs?
You ask me to be the devil's advocate here, because I tend to be fairly skeptical about attempts to take international law much beyond a system for joint regulation of things. I'm not so keen on some colleagues who proclaim that there ought to be an international constitution, or there should be, or there actually is an international constitution. So, at the risk of ducking the question, I wouldn't be the proper person. Believe me, I wouldn't be invited to do that. Not if whoever convenes that meeting has read some of my work. No. I'm sorry, but impossible to answer that.
Much societal difference? Is that why you...
Sorry?
Do you take that position because of the disparity of societal values?
No. Also, I mean, there's 6 billion people on the planet, and maybe 6.2 by now. It's unlikely that we all agree on each and everything. And if we agree, we tend to agree on in the abstract, but not so much on the concreter level. You and I may all agree that torture is a bad thing, but we probably cannot agree on what exactly constitutes torture. I might draw the line differently from where you might draw it. And that's something to take into account. Plus, sort of the general position I'm more and more attracted to is that no matter how good or how wonderfully well built your legal system is, people will always find loopholes. So in addition to having a decent legal system, you also need to have decent people, decent governors, decent people in positions of power. And that in turn means, I guess, that I wouldn't expect too much from a global constitution, if you will. Because even constitutional norms tend to be circumvented when the end seems to justify the means. Oh, that raises a lot of questions all of a sudden.
We're allowing one more, and it's time in the back. So,
With that being said, how do we answer those who argue that international law is illegitimate? It's based on a system of consent. And in this case, the Ecological case, the European Court decided not to cooperate with the UN. How are we going to stop all states from, thumbing their nose whenever, there is no justified means, like you said? How is international law, or can we even call it international law? It's just international politics.
But one of the things, I guess, that international lawyers should do to sell it, if you will, is to make the point that international law is far more flexible than people sometimes assume. Which is why I ended by saying, you sign up to a treaty, you can always make a reservation. That way you're bound by the sort of stuff that you can accept, but you also have an escape clause for the things that you know in advance will be difficult. And that may be at loggerheads with your domestic legal order or whatever. And in order to get there, it might be useful to have a more realistic starting point, not the fairy tale point about treaties being the meeting of the minds and that sort of thing, but rather that treaties are simply the result of political bargaining. Doesn't mean that treaties are only politics, because the law takes a certain life of its own after a while. Well, once the thing enters into force, it is also law. But it does probably help to be a bit more realistic, saying, okay, 6 billion people, we cannot agree on everything. Why not treat treaties as the product of our disagreement and move on to the extent that we can move on together? Something like that. A slightly more realistic attitude, perhaps, on the part of our profession. Does that make sense?
The problem is the scapegoat seems to lead to the illegitimacy. With no force, how can you hold people to what they promise? Their side of the compromise.
I'm not saying that international law has no force, because there's, if you think of international law, let's put this differently. There's 3 models of law, I guess. You have your criminal law model, you have your private law model, you have your public law model, right? Now, if you look at international law as modeled on criminal law, then yes, it doesn't work very well. If you look at it as modeled on private law, then all of a sudden it does a hell of a lot of work, because it facilitates interactions between sovereign entities. It may not always constrain those sovereign entities, but it does facilitate their coexistence. It does facilitate their reaching certain goals together on occasion. And I think that's a great good.